Your Honour, following on from my learned senior, I will now move on to our third submission. The plaintiff claims that the defendant has breached its duty of care by failing to provide a security guard on the night the incident took place. Counsel for the defence refute this claim as per Section 11(1)(a) of the Civil Liability Act 2003. Under the necessary condition test, the presence of security personnel would not have made certain that the harm inflicted on the plaintiff by the offender would have been avoided, as well as the deterrence of the offender from re-entering after being evicted from the establishment. This was also found in the 2009 case of Adil's Palace Proprietary Limited and Morabak and Baunajem, which was heard in the High Court of Australia. After an altercation between patrons had broken out, a man had left and re-entered the premises with a gun. He then shot the two respondents in the mentioned case, and they sought damages from Adil's Palace as they believed that they had breached their duty of care to them by not having security guards present at the time. Justice French states in paragraph 38 of the judgment, "Of course, there is always a risk that there will be some altercation between patrons at almost any kind of event, and the risk of that happening is higher if the patrons are consuming alcohol. But unless the risk to be foreseen was a risk of a kind that called for, as a matter of reasonable precaution, the presence or physical authority of bouncers or crowd controllers to deal with it safely, failure to provide security of that kind would not be a breach of the relevant duty of care. As noted earlier, there was no finding at trial or in the Court of Appeal that a risk of that kind should have been foreseen." Counsel for the defendant wished to reiterate this decision to the court today, to establish the autonomous nature with the matter being heard here. It should also be noted that the defendant does not serve alcohol as they are not a licensed venue, and historically, Sunday evenings are not as high traffic nights, such as Friday and Saturday nights, where TMG, the defendant, do have a security guard present. Under Section 11(1) of the Civil Liability Act, Section 1B refers to the scope of liability. Counsel for the defence would also like to bring into mention the 2008 case of the SRA and SHU in New South Wales. In this case, it was found that the free, deliberate and informed acts of a criminal third party broke the chain of causation due to an unforeseeable subsequent event, nervus actus interveniens, an intervening cause, thus rendering no breach of the appropriate duty of care by the defendant, as the harm inflicted on the plaintiff resulted from the actions of a third party and not the defendant. With the above, counsel for the defendant refute the plaintiff's claim that not having a security guard present breaches TMG's duty of care, as the actions do not amount to factual causation, nor do they fall outside the appropriate scope of liability for duty of care by the defendant. Your Honour, I will now move on to our fourth and final submission. The plaintiff claims that the defendant's breach of duty of care caused him harm. Counsel for the defence also refute this claim based on the following. Under Section 15(1) of the Civil Liability Act, a person, defendant, does not owe a duty to another person, plaintiff, to warn of an obvious risk to the plaintiff. As none of the exceptions stated in Section 15(2) of the Civil Liability Act are met by the plaintiff, TMG had no duty to warn the plaintiff of the risk of harm that he may experience by the offender if he were to leave the establishment and run into the man again. It should also be noted here, Your Honour, that the offender had verbally stated to Mr. Sheen, the proprietor of TMG, that he and his friends were going back to the pub after refusing Mr. Sheen's offer to organise transportation home by way of taxi. The risk was not foreseeable, and the defendant had no duty to warn the plaintiff of any obvious risk. In Modbury Triangle Shopping Centre in Ansell, a 2000 case heard in the High Court of Australia, a video store worker was assaulted by three men walking to his car in the car park of the shopping centre after closing time. Plaintiff claimed that the automatic lights in the car park not being on due to a malfunction was a breach of the centre's duty of care to the man, therefore the centre was being negligent. However, it was stated in paragraph 3 of the judgment of this case that the unpredictability of criminal behaviour is one of the reasons why, in the absence of some special relationship, the law does not impose a duty to prevent harm to another from the criminal conduct of a third party, even if the risk is foreseeable. With the above, Counsel for the defence refute the plaintiff's claim that a breach of duty caused the plaintiff harm, as the elements of factual causation and the scope of liability under Section 11.1 and Section 15.1, no proactive duty to warn of obvious risk, of the Civil Liability Act have not been met. Therefore, our client, the Midnight Garden, has not been negligent in their actions nor breached their appropriate duty of care on the 3rd of June 2018 towards the plaintiff. Your Honour, the defendant recognises and acknowledges that the harm inflicted and subsequently experienced by the plaintiff is serious and of no insignificance. What the plaintiff has experienced is a horrible ordeal, but the defendant is not responsible by way of breaching their duty of care. This harm is the very unfortunate outcome of a third party and their careless criminal actions, not the defendant. TMG did all that they could and are required to do by law to ensure that the plaintiff was safe whilst on their premise and should not be held accountable and found to have been negligent in their actions. In accordance with the law and the precedents of the case law, my learned senior and I have submitted. To be negligent and breach one's duty of care towards another is a very serious and unscrumptious matter, but that is not the case today. Thank you.